Okay, welcome everybody back to the third segment of Totality of Law. And we just got done leaving off with the history of the fight between common law and Roman civil law. And now let's transition from that fight between Roman civil law and common law, and now we'll get into the fight between common law and Maritime Admiralty. So, and this will start to get into the aspect of what the law merchant is. So what is the extent can't be adjudicated in common law? Trust and usufructs, from the aspect of Roman civil law being how they split title between equitable title and legal title. That equitable title is the right to use something, which then makes you the usufructuary, and the legal title is the one who actually owns it, which is, of course, the aspect of all of this registry, everything that you register, your cars, your weapons, your land, your children, all of it. All of it has to do with this aspect of setting up trust under Roman civil law. So the law merchant is, and this is the aspect of the law merchant. The law merchant is part of the common law of merchants. And the common law of merchants goes back basically ever since man decided to take to the sea, or when he first basically decided to trade things over long distances. So in the documents, under the links, under the law merchant, so click on the law merchant and open that up. I'm going to go through each one of these documents and show you what the law merchant's all about. And we went over the thesis paper of the Court of Wards and Liveries. There's another thesis paper for under the law merchant for the Fair Court of St. Ides. And this is where you get into the aspect of the law merchant of where this comes from. So I'll go through each one of these because I'm going to show everybody what each one of these documents is, why I put it up for everybody to take a look at. So the total understanding of the law merchant is an aspect of the common law of merchants, right? So we've got the law merchant here under positive law, man-made law, but it does have a little bit to do with the common law of merchants. It has a little bit to do with equity and fairness of merchants, between merchants and merchants. It has a little bit to do with Maritime Admiralty. It kind of has a lot more to do with UCC, the Uniform Commercial Code, and it has a bit to do with a little bit of statutory law too, and Roman civil law, all wrapped in. So it's all connected to all these. So a very, very good book to start to understand what the law merchant is The Pied Pipers of Babylon. This is a book by Vril K. Spear, who has a doctorate in common law. And he begins right in the beginning of this book, you're under foreign law. And of course, because as it said, that Roman civil law is foreign to us. So I'm not going to read all this, but I'll just show you guys the table of contents, and I highly suggest that you take the time to read this book. Some other people and members of the Vocational Science of Freedom have done so, and they've said that they've learned a tremendous amount of information by reading this book. The key discovery of Dr. Spear is that Americans have become subject to a foreign system of law, essentially a form of Roman civil law. Once again, today, Americans are the victims of an attempt to force this foreign law on them. Whether you call it the law of merchants, maritime law, or equity, slightly different variations taken by the civil law. Now, of course, and that's what I'm showing you guys here. See, reading one single little paragraph like this, when I first read this, I was like, what is all this stuff, right? Well, now I know. You can tell how all of these things connect in, right? And then you are being lured back into slavery by the supposed benefits the establishment would confer on you, such as Social Security and convenient checking accounts. Every single thing that you do in the aspect of the law merchant, they're giving to you as a benefit. And that is completely covered in the Edward Mandell House quote. The class is then explains the New Deal, what they took from you. Edward Mandell House, the man who ran a fool. And you can also find it on Library TV as well, and on Odyssey as well. And it's the one that says no one rules if no one obeys. That's the one that you want to click on, and it'll show you all of the history of what this law merchant system is and how they brought it in to lure you back in here from the aspect of the benefits, right? Table of contents here. We'll just cover it real quick. So, a foreign and unwarrantable jurisdiction. Building the case, theory of cognitive dissonance. This is, people have a problem with. They're not going to understand it. They're going to say, no, that's not happening. Well, yes, it is, and actually it's already happened. So he gets into the understanding that the common law is your birthright. The development of the common law, he gets into a lot of the history of it, which I some of it I covered today, but there's more of it here, which is why I gave a vast majority of all these handouts are for you guys for your homework, right? So take the time to read these books, go over them bit by bit. If you find something neat or interesting, throw it onto the server. Make sure that everybody else reads it too, because these books are on the VSOF library as well. So authorized jurisdictions in America. What's authorized and what is not authorized, right? Torts distinguished from crimes, torts distinguished from breaches of contract, so on and so forth. Law merchant, introduction. So you get down to page 74, it'll tell you what the Lex Mercatoria is. And I put out a request the other day, and a couple people came back with information regarding a book that was looking for called Lex Mercatoria Americana. So it's the Lex Mercatoria, but based on the American aspect of what they're doing here. So that book's been found, was a good thing. And we'll get into finding out what else that information says in that book when we get it. The Law of Nations, and again, this is just it's a good overview of everything, of what's been going on. And again, it's very detailed. So, and you guys can take a look at that one. The next one on the list for Law Merchant will be Introduction to the Law Merchant, which is just a short little treatise of only 57 pages, of which a gentleman wrote, but I've gone through it, and it's correct. It shows you a lot of the good books and things to read, and it gives a pretty simple layout, again, of what's going on here. Defining Lex Mercatoria, the commercial law, substantive law, maritime admiralty, administrative law, and positive law, right? Again, all of these things that interact here, right? You're seeing it. You're seeing what they're telling you here, but you're seeing how they all connect. Law merchant, commercial law, which I didn't really make a separate circle for, but it pretty much encompasses all this. Substantive law, maritime admiralty law, administrative law, which is positive law. So it's just this whole mix of garbage in here. Foundational law merchant, security interests, court of equity. So what are we doing in courts of equity? Security interest, right? They hold the security interest over you, which is what I explained in absolute detail in this lecture that I did. It's the point that they hold the security interest over you forever, basically. Why? Because you end up being a bonded debt slave, and you're not even aware of it, of how this happens. And then it gets into more of the mercantile and the debt stuff, which I won't cover. We'll cover that more in banks and banking in the free classes when we come back around to it in the roundtable. So that's that. Next one on the list, the law of the Jews becomes the law of the land. This is an interesting aspect of how what they did was they changed the law so that their maritime admiralty law merchant garbage came in to control the people. And there's a very good layout of this. It's only 11 pages, so it's a pretty short read, but it has a tremendous amount of references in it as far as going to be able to check all this stuff out and so on and so forth. Because as soon as you bring up the Khazarian mob, of course, everybody wants to attack you and say, that's not true. Well, yes, it is. Okay, so that's that. And next one down the list is an essay on the early history of the law merchant. Not a tremendously long read. I mean, it's 200 pages, well, about 200 pages, but it's very concise and only focuses on the law merchant as far as what these things are and where they came from, and the courts of the law merchant, which will get into the fair court of St. Ides, right? But you can read the treatise here, but this will be an aspect of it. So that's that. Then we have application of the law merchant and arbitration. This is something that we found just not all that long ago, actually. It's 11 pages, but this will help people understand when you guys do your doc set and we start putting them under binding arbitration. This is an aspect of understanding that the application of the Lex Mercatoria in international commercial arbitration and just in binding arbitration in general, how you can run them over with their own system. This is a really short read. Like I said, it's only 11 pages, but it'll give you, if you're interested in understanding the connection between that ancient aspect of binding arbitration and what we do to squish them, it connected with Lex Mercatoria, you can take a look at this and read that out. Then the laws of Oleron. This is what I wanted to connect in with the history of Eleanor, John, and William Lionheart. I'm going to come back to equity here, so I'm just going to skip it down a little bit in the class outline. I'm going to skip down to maritime admiralty and just get back to this because we're kind of getting the law merchant. Now, the laws of Oleron are technically maritime admiralty law, but at the same time, they're also an aspect of law merchant. Because remember, these things do overlap. Okay, so what are the laws of Oleron? or the rules of all around. So basically what these were, they were maritime admiralty rules that were in use in Cyprus and other places in the Mediterranean. And when William the Lionheart and his mom, Eleanor, went down to do the Second Crusades, and they got down around to Constantinople and whatnot, they learned about these laws because it wasn't anything that they'd ever known about, being all the way in England, right? And so they took them and they brought them back. And what this is, what the rules of Oleron, what they are, it says 1266, right? This was eventually what William III, as I told you about, the guy that solidified the aspect of the Maritime Admiralty Court, or sorry, King Edward III. Yeah, not William, Edward. So King Edward III, this is basically what it was based upon. And I'm not going to read these, but it is an interesting read as to what the Maritime Admiralty looked like in 1266. And it deals a lot with what the rights of ship owners are, the rights of the seamen, how to handle the vessel, repairs of the vessel, any aspects of sickness of the mariners, aspect of it, cargo, what you can and can't do with the cargo, and various different things like bills of lading and what the masters have to do and so on and so forth, right? So, but it's a beginning of, if you have absolutely zero knowledge whatsoever of what maritime admiralty law is, it pretty much all starts with the laws of Oleron, or the rules of Oleron. So you can just start there. That's your good, solid basis of understanding maritime admiralty law, okay? And it is the basis of what it became in England, so under Edward III. So that's the laws of Oleron. Then from that, then we get into the last one in the law merchant folder is the Fair Court of St. Ides, the thesis paper for the Fair Court of St. Ides. Now, this is 136 pages, so it's a little bit longer, I think, than the other thesis paper was. But this will help you understand where the merchant courts eventually came onto the land. Eventually, the merchant courts were always kind of sea courts anyway, and they were usually done in ports. But then when they became into the fairs, like literally like, state fair, county fair kind of thing, not meaning fair as in like equal or just. When the fair court started up, that's where the law merchant system came onto the land and started to be used in England. And so it starts out with a story about the Fair Court of St. Ides and what a defendant did and so on and so forth, and how unfair the court is. And that's how this whole story starts out. And then you guys can read the rest of it. And it has, again, it's very good because obviously it's a master's thesis paper, so it has to be sourced very well. And all these sources you can easily go find. So again, but here, so just note this, just in one of I just saw this out of the corner of my eye. What does that say, right? Laws of Oleron. Yep. So anyway, so they're all connected. So the laws of Oleron, all the rest of this is all connected as far as the law merchant is concerned. And like I said, the best document to read first would be Pied Pipers of Babylon to understand what they are doing to us here. Once you get the understanding of what they're doing to us, it's much, much easier to understand how to crush them in common law, because you can see what they shouldn't be doing at all. None of these things with dealing with our land, our estates, or anything, all the rest of this stuff, none of this should have anything to do with the law merchant whatsoever. The reason that they're doing it through Lex Mercatoria is because they're considering all of it to be abandoned, and what they're doing is they're making a profit off of your head in capitalism, you being a bonded debt slave and not knowing it. And then, again, as Edward Mandell House said in the quote in this lecture, he said, "And we shall hold the security interest over them forever, and they will be without redemption." Huh? Redemption of what? Well, redemption of your estate. So now what I'm going to do is so that's the law merchant, and I'm not going to get into a tremendous amount of it. Like I said, the law merchant will be a homework assignment, if you will, for everybody to learn about what law merchant is and how the courts work and how progression of the courts from the fair courts all the way to what they're doing now is in connection with everything else. So that was the law merchant aspect of that. So the law merchant, now we go equity. So this gets back to, and I don't have too many things in here for equity because I'll cover equity a lot more in the April class, but as far as the March outline is concerned, the law merchant, which is a connection. The law merchant is basically a combination between kind of these two and a certain aspect of the common law, being that is a common law of the merchants. So it's a combination between equity, maritime admiralty, and common law is what the law merchant is. So here you see law merchant, you see equity and common law and maritime admiralty, and so it touches all of those. So now what is equity? Okay. So the aspect of what is equity, I did and explain to you guys the starting of where chancery courts came from. So that's where you get the beginning of the chancery courts. Covered that in section 2. So anybody that's listening online, go back to section 2 and watch that one back over. So it was in the chancery courts where it started with the aspect of equity. So basically it's what is fair and just. So where does it come from? It comes from the chancery courts, which we read that section. What matters are adjudicated in equity. So we have contract matters, statutes that deal with contracts and licenses, and it is the principle of law that private agreements will always overrule the Constitution and Bill of Rights. Now, some people have said to me, well, that's crazy. You can't overwrite the Constitution. Well, it's written in the Constitution, in case you haven't read it. It specifically says that there shall be no law passed abrogating the right of contract. And guess what? That same phrase is in every single state constitution. You wonder why? So that they could come back and do this. So they could come back over the top of you and put you into contracts of which you were unaware of and run you over with them. Thus, specific agreements governing individual circumstances will always overrule broad general clauses found in the Constitution. Or expressed in other words, it is irrational to allow someone to enter into a private agreement with someone and then allow him to take a clause out of the Constitution, off point and out of context, and allow him to take that clause and use it to weasel, twist, and squirm his way out of the agreement, all while retaining the financial gain the agreement gave to him in the first place. This is irrational and judges won't allow it. But the first thing you do when you're in any of these situations, as far as these inferior courts are concerned, produce the contract. And I mean produce the contract on first instance, meaning at the side of the road. If it's dealing with a cop or anybody else, doesn't matter. Anytime you first come in contact with any actor, let's call them actors, that's what they are, actors of the corporate state, first thing you ask them, or first thing I say to them is, I don't have any contracts with the corporate state. What do you want? Their eyes will get cross-eyed, and sometimes they'll turn their head like a dog listening to a funny noise. And I'll be, yeah, that's right. I don't have any contracts with the corporate state. What do you want? I'm one of the people of, wherever you're at, I'm one of the people of Wisconsin, right? I'm one of the people of Michigan. I'm one of the people of Florida. What do you want? I don't have any business with you. I don't have any contracts with you. However, if you keep pestering me, you're going to enter into my contract of which I've served on your boss. So what are we doing here? Right? And that, of course, is the KW and the rest of the status stocks from the VSOF, which will put them under contract if they attempt to administer your estate, particularly after you've established the fact that you're in common law, right? You have no contracts with these fools, so you're not in any of this garbage. I'm over here. I'm safe. I'm over here. And if you step on me, this is where you're going to end up, in a superior court of record or binding arbitration, which I said I'll probably add another circle and just put it down here. And because I'll bring this back up, this whole outline I'll make sure that I bring back up during the April class as well, so that those that weren't here for this one will be able to get at least a gist of what we covered here. So, okay, so from that, so that's equity. Now, what do I have? I'll show you guys what I've got in the equity folder. Now, again, this is for everybody's homework assignment. So, principal treatise on the laws of contract. Think that might be important to read? Yeah. Everything you've ever wanted to know about contract law is in this book. All of it. Outline of a subject, analysis of agreement, distinction of contract from agreement, analysis of obligation, distinction of duty from obligation, forms of obligation. See, these whole things, duties, obligations, they're different things in contract law. You guys got to understand what these mean. But I'm not going to get into them today. So I gave you the book. So, agreement traceable to question and answer, forms of which contract may originate, so on and so forth. Form and consideration. What did I say? If there's no lawful consideration, you do not have a contract. Formal contracts, simple contracts, consideration, capacity of parties. If you're an infant, can you enter into a contract? Nope. Infancy, ratification at common law. How do infants, if you do enter into a contract when you're an infant, when does it get ratified at common law? This can happen, by the way. So pay attention to this, because this is how they're getting a lot of us. The reality of consent, right? You don't have consent, no contract. Legality of object, is it a legal operation of contract? This goes into the operation of contract, and then I'll get to all the rest into it. Anything you want to know about contracts in this book. Now, one other point about just these books in general, treatises in general. Okay, folks, if you want to know anything about a subject, find the treatise on it. Find the treatise on it. That'll tell you what's in regard to that subject. Now, I have a treatise folder, which I'm going to open up and just kind of show everybody here. This is the totality of my treatise folder. Now, I have backups of all the rest of this stuff and all the rest of the places under different folders regarding what they are. So this is just simply every single treatise I've ever downloaded. And I've not read, obviously, all of these, but a lot of them. And I've gone through a tremendous amount of them. So a treatise is basically the canonical text of whatever a subject is. So treatise on proceedings and equity. There, that's going to tell you everything. Treatise on principles and practice of life insurance. There you go. Treatise on possession of land in England. A treatise of navigation and nautical astronomy. Nothing to do with law, but it's a treatise, so I threw it in here. So you want to learn about something, find the treatise in it. And I have picked specifically the best treatises that I've ever found for law to go into the folders for this lecture. I've labeled them out, segregated them out as best as I could. Now, there is, no kidding, and I'm not trying to scare anybody here, but there is probably at least 3 to 4 years of learning just in these folders. It took me 25 years to find each and every one of these documents that are the best documents for each one of these subjects. Meaning, the equity law, the treatise on equity pleading and practice, this is a practically 1,000-page book, and this is the best book I've ever seen on pleading and practice for equity. And it's based for American jurisprudence, okay? So, jurisdiction of the equity court, pleadings and practice in equity, the bill in equity, because remember, like I said, in equity, you have a bill. In statutory, you file a complaint, and at law, you have an action. Parties to the bill, drafting the bill. They'll show you how to draft the bill. Oh, by the way, side note on drafting bills, if you ever want to draft a bill for, say, going directly to a legislature because you feel that the state owes you some money for something, like what we're doing right now in Colorado with Drew's arbitration award, which is $190-some million. This is a really good aspect of how to draft from it. So it'll tell you the 9 parts. Because here's the thing. There's 9 parts of a bill. I don't know if you guys can see this. I might be able to blow it up a little bit. Okay. There's 9 parts of a bill in equity, and there's 7 parts of a declaration at law. Now, I won't. This is getting deep into process, so I'll leave this for April. But the point is that once you know how to draft these things, it's not rocket science. They're not that hard to put together. All you need is a decent template. So here's your template. All you need to do is follow the template. Everything else will fall into place. Obviously, you know the facts. Not a problem. Obviously, you can pick the law. Again, not a problem, because I've given that to you too. So all you need to do is just put the 2 together. Once you put them together, you can do the bill or the declaration or the action. I don't care what it is. It's not rocket science. Anybody can do this. Another aspect of the fact that anybody can do this, the course Jurisdictionary, that's an equity statutory course, which is not mine. There's a gentleman named, but his last name's Graves. Anyway, he's an attorney, but okay, he's at least a decent attorney because probably one of the only few that I know. He created this course so that people could actually operate in this statutory system that we have going on, which is all the rest of this mess connected with it, but actually operate in the statutory system and be able to have decent results. If you're not up against a completely corrupt judiciary or a completely corrupt attorney on the other side who is either manipulating the record, manipulating evidence, or manipulating the court. Again, that's where you go over here and you file a suit in a court of record and you say, nope, I'm going to let the jury hang your ass because of everything that you did over here. Perfectly legitimate, best way to go about it anyway. But if you want to know about that side of the system and you want to be able to learn and do that side of the system, then the course Jurisdictionary is the best course to buy, and it's not all that expensive. I think it's only like $250 or something like that. It's well worth the investment. It was one of the first things that I ever picked up, and I got a very, very good basis of how courts work, how the flow of court works. And again, I know I'm getting the process, which we'll cover all this in April, but it was really worth it. So anyway, so I'll get off my soapbox on that. So anyway, so this is pretty much the only book you'll ever need on equity. Now, there are more of them, and I think I do have some other ones in the VSOF library, but we can do ecclesiastical law. There isn't too much I have under ecclesiastical law, but I just did want to, again, make sure that you guys had the understanding of what canon and code is. So let me show you something here real quick. So I'll go into ecclesiastical law, and I'm going to open up the Code of Judicial Conduct for Illinois. Okay. So this is canon, right? This is judicial canon for Illinois. Canon law, ecclesiastical canon law. This is for judges. Judges have to follow canon. Why? Because they're priests. Okay? So, preamble. Our legal system is based on the principle that an independent, fair, and competent judiciary will interpret the law and apply the laws that govern us. Govern who? Not you. Not me. Them. The role of the judiciary is central to American concepts. Concepts, not American truth of justice, but concepts of justice, and the rule of law. It's just interesting. 2 sentences, you can tear apart how bullshit they are. Intrinsic to all provisions of this code are precepts that judges individually and collectively must respect and honor judicial office as a public trust, at least I got that part right, and strive to enhance and maintain confidence in our legal system. The judges, as an arbiter of fact and law, for the resolution of disputes, and highly visible symbol of government under the rule of law. Really? Why are they being a trier of fact at all? Well, that's because you're stuck over here. You're stuck in a system where you actually have a judge, instead of over here, where you only have a magistrate, right? So I'm not going to read this whole thing. Probably make my head explode. But let me skip down here and just show you some of this. I won't bother with terminology. Let's read some of the canons, just so you get an idea of what like a canon is, okay? A judge should uphold the integrity and independency of the judiciary. An independent and honorable judiciary is indispensable to justice in our society. A judge should participate in establishing, maintaining, and enforcing, and should personally observe high standards of conduct so that the integrity and independence of the judiciary may be preserved. The provisions of this code should be construed and applied to further that objective. Okay, great. Kind of a general thing, right? So I'm just going to flip down here to something that might not be so general, like disqualification. How about that? A judge shall, whenever you see that word, it's absolute. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or party's lawyer or personal knowledge of disputed evidentiary facts concerning the proceeding. The judge served as a lawyer in the matter in controversy, or a lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter, or a judge has been a material witness concerning it. Guess what? In small towns, that's going to hit every single one of them. I can almost guarantee that. The judge was, within the proceeding, 3 years associated in the private practice of a law with any firm or lawyer currently representing any party in the controversy. Again, small town, going to hit all those. And I'm just going to skip over some of these other ones. But the point is, here's about the thing about the bias or prejudice. All right, say you go into traffic court. You want to screw these people up? Go into traffic court sometime. Well, don't do it on purpose, but if you find yourself in there, ask the judge one question. Say, Your Honor, do you have a driver's license? Problem. Personal bias. You have a contract with the state who happens to be the plaintiff in a matter concerning the exact same thing of which you are adjudicating here. Can you possibly be non-biased? Of course not. And you're never going to find a judge that doesn't have a license. So, right there. You squish the whole bloody thing. So anyway, you can have fun with these, read these if you want to, but you can find your own state's judicial canon. And if you want to slam them upside their head with it, be my guest. But you're doing that just remember, you're doing that over here. So if you're going to do that over here, you might want to make first sure that you're a plaintiff over here so that they don't squish you. Because if you get too pissy with them about all this stuff, they'll do everything from hold you in contempt to have a fitness hearing. And a fitness hearing means competency, which means they'll turn you into a lunatic, right? Because what does the state have control over, or the king have control over? Which then the powers get transferred to the state. Infants and lunatics, that's right. So they'll use a pseudoscience called psychology to have a competency hearing and then throw you in a mental ward because you dared to tell them that they're not following their own priestly bullshit. So I'm not going to read the rest of this. But anyway, so there's your aspect of canon, or one of the aspects of it. And that's Illinois. So American ecclesiastical law is one of them. The summary of law and practice in the ecclesiastical courts. I believe this one is English. Let me double check this real quick. You can always tell if it's based on English law because it'll say this at the bottom. It'll be printed in London, usually. It'll say law publishers, and that'll usually be in Old English. And then it'll say Temple Bar. Temple Bar in the City of London. Okay, so this is English, but it's, again, I threw it in here because a lot of this ecclesiastical court shit comes from England, and what they were doing as far as courts of wards and liveries, as far as matters of probate, right? So that's where that gets started. A practical treatise on ecclesiastical courts, probate, and administration. This is 1830. This will probably have a lot more. Yeah, actually, this one will be a lot more specific as to probate matters. So it's a prerogative court. Okay, whether probate administrators granted by the prerogative court, whether they are not bona notabilia in another diocese, yada yada, and then this will give you the ins, the various different aspects of what they were doing, and then I give you one book on American, the best book I found on American ecclesiastical law, which you talk to any attorney, they'll say it doesn't exist, but it does. And so this is 1866. The law of religious societies, church governments and creeds, disturbing religious meetings, the law of the burial grounds, so on and so forth. Now, this is not going to deal with as much of things regarding probate, right? This will be more straight what you would consider to be things, just matters of the church. However, I put this in here so that you could see how much of this is actually incorporated in each state. So there's various different states of, all the states are covered in here, meaning that it's a very good book to have as far as the subject when it comes to being able to see what's going on in each and every state. So I'll just leave it at that. You guys can take a look at that. And again, always, if you want to use any of these things, you can always use them as reference guides by just holding down Control and hitting F, and the little find button will pop up, and then you can place anything you want to in there and go search for it and find the information for it. So that's American ecclesiastical law, covered the canon, so that's that. So now Maritime Admiralty. So I showed you the laws of Oleron before, or the rules of Oleron, and what the basis of the Maritime Admiralty is it starts with Clerk's Praxis. This is the book that starts everything, basically, as far as Maritime Admiralty law is concerned, regarding American things dealing with American Maritime Admiralty, and a lot to do with English as well. You get it going with Clerk's Praxis, and then, and this it took me a long time to find this book that it wasn't in Latin. But anyway, hold on, let me show you the thing. I don't even know if this book has this book might not even have a table of contents, come to think of it. Oh, wait, no, I guess that is it. Just in 3 parts. All right. The Court of Admiralty in 3 parts. A historical examination of the civil jurisdiction of the Court of Admiralty, a translation of Clerk's Praxis with notes on the jurisdiction and practice of the district courts, and a collection of precedents. So there you go. And by the way, 1809 goes back quite a ways. The Maritime Admiralty, you get started with Clerk's Praxis. This is the start of it. And then from here, the book that all U.S. District Court judges have in their chambers is this one. This is what the judges refer to as the Benedictine, because it was written by Erastus C. Benedict. And this is the American Admiralty and its jurisdiction and practice. This is the book that they all keep in their federal court chambers, and which they do not ever allow the attorneys to take with them. And there was a gentleman who, can't remember his name, but did some very specific reading and finding in this book as to exactly what they're doing, not just in U.S. District Court, but they're doing it in all district courts, meaning your state district courts are doing the same shit. They're running the same procedures in Maritime Admiralty as it shows in this book. And what I wanted to cover here was this interesting little chapter. I'm just going to highlight that real quick. And so the strife between the common law courts and the Admiralty in the 16th and 17th centuries. Yeah, the English Admiralty at the time of the American Revolution, also important, because this was part and parcel, well, if not the main reason. Well, technically the main reason was because they wouldn't allow the colonies to create their own banking system. So they were automatically, instantaneously, and forever indebted to the filthy Khazarian mob, better known as the Rothschilds. And so, but these two chapters, very important as far as history is concerned, to understand what the fight is, what the fight was, the fight that's still going on. Let me scroll down here really quick to, there we go, bam. All right, so the strife between the common law courts and Admiralty courts of the 17th centuries. Up to this period, the strife between, and let me bring up the thing here so we can take a look at this kind of at the same time we're looking at it. We're reading it. So up to this period, the strife between the two jurisdictions was a less hostile rivalry than at a latter period, when the Admiralty Court was the subject of much irrational jealousy and strong controversy. Yeah, irrational jealousy? Not exactly. I still have the same problem with it today. Okay? And in the 16th and 17th century suffered much from the violence of this jealousy. Jealousy, says Edwards, is perhaps a mild word to apply to the passion with which the superior courts, right, superior courts of record, took up this question. For there appears to have been more greediness than emulation at the bottom of it. Well, greediness on the side of the Maritime Admiralty courts, absolutely. But of course, you got to remember, this is an attorney writing this in favor of the Maritime Admiralty law. Well, yeah. It was, says Breen, for more jurisdiction for gain, not for the public good, but that one jurisdiction might swallow up the other. Well, as far as I'm concerned, there should never have been Maritime Admiralty law in any reason coming onto the land. So, yeah, not swallow it up, but throw it back into the ocean where it belongs. It is to be regarded that to no less a personage than Lord Coke is to be ascribed the origin of this jealousy. And that being the case, is it not wonderful that others should, from subserviency to the opinion of so great a man, have followed the same track, or even have gone beyond it? Matters raged so high that a war was declared between the two courts. This and side note here, the wars were usually fought in what was called habeas corpus, or writs of prohibition, which we'll get into here. Prohibitions were hurled from Westminster Hall and without much order, serving therefore more to irritate than to subdue the Admiralty Court, which, though powerless and without any means of attack, obstinately held out for its ancient and time-honored privileges. Well, yeah, that's a flowery way of saying the filthy Khazarian mob wouldn't let go of what they'd finally been able to bring onto the land. Just put it that way. In 1575, in the reign of Elizabeth, the judges of the Admiralty and common law judges, before the controversy, had assumed that angry charter, which it afterwards exhibited, entered into an agreement on the subject of prohibitions. To this agreement the Queen does not appear to have been in any matter a party, but it indirectly had the effect to keep the peace between the two jurisdictions, as subsequently during the reign of Elizabeth no prohibition appears to have been issued against the Admiralty, except 2 or 3, which are mentioned by Lord Coke in Fourth Institutes. I didn't put in Lord Coke in his Institutes because it predates Blackstone's commentaries by a bit, and They're a little bit difficult to read because they're kind of written in Old English. And they're a lot of what is in them has morphed so much that unless you know the full history of it, it would just confuse most people. So, and not to say that any of you are not intelligent, that's not what I'm getting at. What I'm saying is that it's not conducive to actually worry about reading Coke unless you are purely interested in the history of it. It doesn't help to solve our situation, is what I'm getting at. The agreement of 1575 is worthy of notice as an evidence that the common law courts claimed a sort of legislative or prerogative power in matters of jurisdiction. They do not so much appear to be deciding principles and declaring the law as granting requests, consenting to agreements, and making promises. It was indeed so. The law was on the side of the Admiralty. The power was in the hands of the common law judges. So, this is the agreement that they came to. Basically, and I'm not going to read all this, but basically what it meant was that, okay, you've got your stuff going on over here, we've got our stuff going on over here, and you guys in common law courts are going to stop sending us writs of prohibition to stop doing things that we have the right to do under Maritime Admiralty. That was more or less along the lines of where this peace finally came to. They finally agreed to stop fighting with each other, more or less. And since Queen Elizabeth was in her early years, in her early reign, kind of having a whole entire country that was in strife, to say the least, she pretty much just let them work it out between each other anyway. But to give you an idea, that after judgment or sentence, definitive given in the courts of the Admiralty in any cause and appeal made from the same to the High Court of Chancery, that it may please them to forbear granting of any writ of prohibition, either to the judge of the said court or to her majesty's delegates at the suit of him by whom such appeal shall be made, seeing by choice of remedy that way, in reason he ought to be contented wherewith, and not to be relieved by any other. So this was this agreement, this kind of like truce, in a way kind of set in motion the idea that if you've got a case going in here, we don't move it over here just because, somebody wants to. Or if they've got a case over here, we don't move it over here just because they want to, unless there is absolutely no jurisdiction for it to be had. But that was not what this agreement was about. It was agreement that you've got yours, we've got ours, we'll be happy not playing politics, basically. Because that's what courts are. Courts are just political entities that want more power. Surprise, surprise, right? And that's an interesting little part of the war back and forth between those two courts. So that's Maritime Admiralty. And make another note here. So we've got Maritime Admiralty, that's then the laws roll around. There's some other things in here. I gave everybody this aspect of what a tontine is. A tontine is basically a kind of an insurance scam, basically. The interesting thing is that people have referred to the entire United States government as a tontine or Exxon Ponzi scheme. And after you read these 4 documents, you'll get a gist of what I'm talking about, because the tontines of like life insurance and schemes under life insurance, okay, you take that and you blow it out into what is now going on with the entire system of law, finance, the law merchant, all of it. All of it basically goes back to this aspect of a Ponzi scheme and the Exxon or the exempt elect and what they're doing. So this is only 4 pages. The tontine insurance scheme is only 17. So these are short little things that other people put together. I didn't put these together, but I thought they were very interesting reads as to what is going on. And when you connect the dots with that being a Maritime Admiralty insurance Ponzi scheme, also with what Edward Mandell House said in the quote, all these things start to come together. They're all connected together. And just so we're not overly worried or connected with YouTube here or being dependent on it, I have moved and back up everything now on library TV. You can use it as Odyssey. Either one works. It goes to the exact same things. And so I also have the same lecture in here, right here. So no enrolls, no one obeys. Just look for that, and you can watch it off of Odyssey as well. And I'll drop the link in the chat just so everybody can know how to get there. So yeah, the fact that there's this Ponzi scheme going on with all of these insurance policies. One of my better mentors over the years, her name is Tammy Peppermint. She explained to me that I said, well, it's the banks and this. And she's like, no, it's not the banks. I'm like, what do you mean? She's like, the banks are secondary. She said, everything starts with the insurance companies. And, cognitive dissonance kicks in because you get into the red pill, diving into the rabbit hole after a while, and you're like, yeah, it's the Federal Reserve and the money. But I wasn't going back far enough. I didn't realize that the insurance companies originate from Maritime Admiralty merchants. And that was what came first. Maritime Admiralty insurance came and existed before banking. And I didn't know that. And so when I went back and I did the history and I saw what was going on, then the UCC made it totally made sense. I was like, oh, okay, I get it. Military law we covered. So, and then I have some other treatises here for you guys on federal practice. So the other way that you can, at least in American jurisprudence, that you can think about this map, is that there's state law, which is pretty much here, and then there's federal law, which kind of covers, like I could probably put it like a kind of a circle, something like this, where it kind of covers basically everything over here, with the exception of the common law. And so you have state and federal courts. So what I did was I gave everybody a treatise on federal practice, so you guys can know in case you ever have to deal with the feds one way or the other, as to what to deal with. And the other thing that would go along with this, which I didn't add, but you can find pretty much anywhere, is the Federal Rules of Civil Procedure. The Federal Rules of Civil Procedure is what governs how everything works on the federal side. But we will get into all the aspects of practice and procedure in April. And then one of the other last things that I have is practice, pleading, and forms and actions, both legal and equitable. So that's at law and equity, in 3 volumes. And this is 1870. So this is 1 year before the United States Federal Corporation came into existence. And yes, it is it says it's for Iowa, but you can really use it as a document for really any state. So you guys can look over that at your leisure. And let's see where else we're at for. Let me get back to the outline here. So now the different kinds of courts. So you have superior courts. Okay, one last thing. This was the other thing that I was going to read to cover the 5 jurisdictions of law when we're looking at the outline here. So I'll cover this last one, and then we'll get into what's a superior or inferior court. So this is from an elementary treatise on the common law by the use of students by Henry T. Terry, 2nd edition, 1906. And I made sure that you guys have this in the common law folder. It's right here, elementary treatise on the common law. So you guys can take a look at that. It's a pretty big folder, and it's, unfortunately, I don't know how this thing got scanned, but all the information's in there, but sometimes there's some goofy stuff that's like doesn't look quite right. So I don't know what happened to the scan when they did it, but anyway, it looked like somebody scanned it and then converted it and then didn't get around to correcting like all of the messed up conversions or something. But it's the only digital version I've been able to find. So the present Anglo-American law is made up of 5 parts or subdivisions, namely 1, that part of which is called by way of distinction law, which means common law. 2, equity. 3, maritime law. 4, ecclesiastical. And 5, military. Each of these consists partly of unwritten or customary and partly of written law. In all except the last, the unwritten element is by far the larger and more important part. That, of course, being military. That's all written. So I'm going to skip my note because I already talked about that. Law in the special technical sense above mentioned comprises the common law, much modified by statutes, and 2, the mercantile law, law merchant, lex mercatoria. The latter is founded upon the customs of merchants. It does not, however, like the commercial codes of some European countries, comprise the whole of the laws relating to mercantile transactions. Those are mainly governed by the common law. Sale and agency, for instance, are frequent transactions in trade, but they fall mostly under the dominion of the common law. The mercantile law consists of a small collection of rules relating chiefly to a few subjects, for which the common law furnishing no sufficient rules. The courts fell back for principles of decision upon the practices for which they found prevailing amongst merchants. Again, bank and merchant affairs, bills of lading, things of that ilk, right? The most important of these subjects are bills of exchange, promissory notes, and maritime insurance. Bingo. All of which contracts are of comparatively modern origin and were introduced to England from the continent of Europe, so that the mercantile law is largely an importation from civil law countries, Roman civil law, right? And in many points follows civil law principles. In a certain loose sense, however, the name mercantile law is sometimes applied to all that part of the law which relates to trade and commerce. Okay, fine. That's kind of how I see it as far as the law merchant is concerned. Equity is a supplemental system of law which grew up by a particular process of judicial legislation. Right, chancery, which we talked about, by the side of the common law to supply certain deficiencies. That's why I put it here. By the side of the common law, because it is an aspect of common law. Equity is an aspect of common law from the standpoint of being fair and whatnot, but it's also an aspect of the law merchant. My note here, not to overrun or alter what is law, meaning the common law, but only to fix what is not covered, namely the contracts which the attorneys themselves created to circumvent the common law to begin with, like trusts, usufructs, and all the rest of this garbage they were talking about, which found to exist in the latter. It differs from law in two respects. First, equity recognizes and protects certain rights of which the law takes no notice. These are called equitable rights or trusts. Equity deals with trust and trust law. If you don't have a trust, what are you doing in equity court? Where's the contract? When equitable and legal rights conflict, the equitable right prevails. Why? Because it's the basis of contract. That's why. Which the common law won't help you get out of, because if you signed it, well, you're in it. Or if you did something, then you agreed to it. Thus, if property is given to A in trust to B, A becomes the legal owner of the property and is the only person whose rights are recognized at law. But equity will compel him to hold and exercise his legal rights exclusively for the benefit of B, who is the equitable holder. Again, this gets into the aspect of the splitting of the title. Legal right, meaning legal title, compared to equitable, right? Equitable owner. It's not, you don't really own anything in equity, you just get the aspect of using it. This double system of rights resembles that of the Roman law. Surprise, surprise. And indeed, the relation between law and equity is closely analogous to that between jus civilis, meaning civil law, Roman civil law, and jus natural law. Secondly, equity in many cases enforces legal rights, which would also be enforceable at law by giving different remedies. Thus, a contract is binding at law, creates a legal right, but if one party breaks his agreement, the other has no remedy at law but to sue for pecuniary damages. Equity, however, will sometimes interfere and specifically enforce the contract by compelling the party to do the very thing that he has agreed to do. You see, the problem is, at common law, you can't force a sovereign to do anything. Right? So at law, there is generally no remedy against a wrong till it has actually been committed. But equity often grants an injunction to prevent a threatened wrong. See, in equity, you can go cry to daddy and say, he's not going to do what he's told you said he was going to do. And daddy will say, okay, I'm going to put an injunction on the infant. There is no injunctions at common law. Just know that. Okay? And yes, it's the aspect that the wrong actually has to be committed. Because in here, we're dealing in fiction land. This is nothing. It's fairy dust. Okay? This is real. This is, he might do it. No, he did it. Okay, hang him. Right? So, the maritime law is a body of rules relating to shipping and commerce by sea, though the common law also furnishes some rules on those subjects. It is derived from the customs of seafaring men and merchants, not only of England, but of other nations, as I showed you where it came from to England, which is the laws of Oleron. Like the mercantile law, therefore, it is largely of foreign origin. This part of the law is nearly all the same all over the world and contains a large element of Roman law, which is what? The UCC. That's what the UCC is, okay? The English ecclesiastical law, okay, so we went from maritime, no, I'm skipping around here, because it's all out of the same book, but I pulled this out of a lot of different sections. So now, ecclesiastical. The English ecclesiastical law consists of two parts. The first part deals with the organization, doctrine, and discipline of the Church of England. Okay, great. Which is established by the laws as the state church. Wonderful. This is ecclesiastical law in the proper sense. In the United States, there is no established church, and therefore no ecclesiastical law of this sort. Churches in the United States are merely voluntary associations and come under no ordinary law. What is there called ecclesiastical law is merely the rules which those bodies have adopted for their own government, in which their legal aspect amount to contracts between their members. The second part of the ecclesiastical law comprises the law relating to the probate of wills and the appointment of administrators. So, if you're going around appointing administrators, because that's what administrators are, they get appointed. I've covered this before ad nauseum, so I'm not going to go over it again. But an executor is someone who gets placed in their position by a will, not appointed by a court or by a priest of El. So, that's why you have to do your Vocational Science of Freedom status docs and get your executor appointment done. Because once your executor appointment is done and it's placed under the probate record at the county recorder's office, then you are a proper executor. And all administrators can go to hell. Because the executor is the one that can control the estate for the heir who has been found to be living. So, comprises the law relating to the probate of wills and the appointing of administrators for the estates of deceased persons. Now, you might say, well, how does that have anything to do with us? Well, if you go look in your IRS master file, if you get it from the IRS, you'll be labeled as a decedent in your IRS master file. So what does that mean? It means they consider you to be dead. Sort of. Basically, you're pending. You're not alive, you're not dead. You're pretty much always pending. Because they don't know where you are. Because they don't want to find you. They don't want the actual heir to come forward and say, yeah, by the way, that's my stuff, stop it. And give it to me, and I want a full accounting, and if you don't, here's a contract to put you under, which is what we do. So, and a portion of the law of marriages and divorce. So, marriages and divorce, everything about the family. Probate of wills, everything to deal with your property. So, ecclesiastical law pretty much controls everything, if you want to look at it like that, right? So the church claimed, and in former times was permitted to exercise an extensive jurisdiction over the last two subjects on the ground that marriage was a sacrament. How the subjects of probate and administration, which have no sacred character, happen to fall under its jurisdiction will be explained in another place, which I've kind of explained that already. In the United States, marriage and divorce are regulated mainly by the rules of law, the principles of the old ecclesiastical law being admitted only to a very small extent. Well, that's debatable now. Because you got to remember, the time of writing this, 1906. All of this just did a 360 after 1933. The New Deal, all of this got changed. It all basically went exactly the opposite of what this is saying. So probate and administration together with a few other subjects still form a partially distinct body of law having no specific name. Well, yeah, they do. Which is committed to the care of a separate set of courts called probate courts. Now, as far as I'm concerned, after 33, they're all just running everything through probate. And the law merchant is making a profit off of what they're originally doing at probate. That's how I should put it. The ecclesiastical law based mainly upon the canon law, the laws of the Catholic Church. Right. Yeah? So, again, the cult of Rome is controlling you. That law was derived partly from the Roman law and partly from the ecclesiastical legislation of the popes. That's why I connected these two. So we've seen in other books where it says ecclesiastical law and Roman civil law don't. Well, yes, they do. And here's the other right here. In the year 1151, Grattan, an Italian monk, made a compilation of it in 3 books known as the Directium Gratiani, probably, yeah, from his name, to which the latter times various popes added constitutions or regulations of their own. These make up the Corpus Juris Canonici, so the Corpus Juris of the canon, right? Now, there is one other book that I want to bring up as far as history is concerned of the connections of these things. Okay, so under foundational documents of law, that's why I put it there, because it has to do with a lot of the things that happened during the Middle Ages. Okay, so select documents of the Middle Ages. Okay, the reason I wanted to get to this now is because we finally kind of covered ecclesiastical law. And what I want to get to as far as the cult of Rome is concerned and what they've done and why all of this has stayed under Roman civil law filth for so long is actually shown in this document. Selected documents of the Middle Ages. Okay, so I'm going to bring this up. And what I did was with this is I did not give you the whole totality of the book because there wasn't much point, because there's a whole bunch of stuff in here that's completely irrelevant to what we're talking about. But what is relevant is Magna Carta, Statute of Mortmain, General Summons of Pope Innocent III to a crusade. Notice the date, 1215. This is when the barons said, okay, we're going to get your ass because all you fools went off to crusade, or they went off to do a summons, right, to a crusade, right? So they all took off, bam, going to get you. And then the other two that are very important, is John's concession of England to the Pope, 1213. 2 years before the Magna Carta. I'm gonna read this and show you guys what this fool did, and then I'm gonna show you the aspect of unum sanctum. This is where the Pope decided to take the entire planet into trust for himself because he's the vicar of Christ, because he's just holding the world for a little while until Christ comes back. So he says, by his own decree. So what I did was I just put these parts in here. Okay, so that's all this is. It's just 24 pages of the book. So in Magna Carta, which I won't get into because we've already read it, but this is the whole entire Magna Carta, so you guys can have fun reading that. So let me get through down to 62 here. Whoops. Okay, or sorry, 63. So Statute of Mortmain. This one's interesting because this is where Edward I said, you know what? Everybody's going to stop giving land to the filthy cult of Rome, to a corporation that never dies, right? So he said, all right, no more mortmain, mort meaning dead, and then this is where you get the term mortgage, by the way. Mortgage, mort meaning dead, gage meaning pledge. A mortgage is a dead hand pledge, people. And anyway, so he said, nope, you're not going to keep giving lands to the church anymore. So that was that. You can read that. This is what I wanted to get to. John's concession of England. Yes, you heard that correctly. John's concession of England, meaning he gave all of England to the Pope. Not a joke, actually happened. John, by the grace of God, King of England, Lord of blah, 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 blah. We wish it be known to all of you through this our charter, furnished with our seal, that inasmuch as we have offended in many ways God and our mother, the Holy Church, and in consequence are known to have very much needed the divine mercy, and cannot offer anything worthy for making due satisfaction to God and to the church, unless we humiliate ourselves and our kingdoms. We wishing to humiliate ourselves for him who humiliated himself for us unto death. Talking about Lord Jesus Christ, but of course he doesn't say anything about that. The grace of the Holy Spirit, inspiring, not induced by force or compelled by fear, meaning we're doing this under our own volition, but of our own good and spontaneous will, and by the common counsel of our barons, bullshit, do offer and freely concede to God and his holy apostles, Peter, Paul, and to our mother, the Holy Roman Church, and to our Lord, Pope Innocent, and to his Catholic successors, because corporations can't have heirs, they can only have successors, the whole kingdom of England, and the whole kingdom of Ireland. What? With all their rights and appurtenances, which is everything that's attached to the land, for the remission of our sins and for those of our whole race. What? And what does he mean? And for those of our whole race? No one ever picks up on that. You have any idea who he's talking about? He's talking about the Jew. He was a protector of the Jews. William the Conqueror was a filthy serpent seed line, Luciferian fool. This is his offspring. This is who he's talking about. He's not talking about the actual people of England. He's talking about the Jews, our whole race. And of course, what are they going to do? They're going to give it all the way back to their Roman scumbags, which is where they come from. Because again, that's where they are. That's where they come out of. And before that, like I said, they came out of Yahudi exiles. It's always been, always will be human sacrificing scumbags. So anyway, back to this. As well as for the living and for the dead. So he's going to talk for the dead people now, right? And now receiving and holding them as it were. Here's the thing. The aspect of for the dead, reaping of souls. That's what the black priests of El are doing in courtrooms. They're just reaping souls. That's it. Because you're a dead vessel. They own your soul because, well, they own most people's souls through baptismal certificates. You want to talk about the absolute bottom of the dirt of this bullshit? It's baptismal certificates and it's birth certificates. You get rid of those two, guess what? They don't have claim anymore. Not that they truly had claim before, but that's the aspect of holding the security interest over them forever. Well, you didn't know it had to deal with your soul too, did it? Well, it does. And now receiving and holding them as it were a vassal from God and the Roman Church, in the presence of that prudent man, Pandulph, subdeacon, and of the household of the Lord Pope, we perform and swear fealty for them to him, our aforesaid Lord Pope Innocent, and his Catholic successors, and the Roman Church, according to the form appended. So this is what John did. He gave all of England and Ireland to the cult of Rome. You think the barons were a little pissed off about that? Yeah, a little bit. Okay, so this happened in 1213. Yeah. And then the Magna Carta happened. The barons said, nope, not happening. And then the scumbag comes back with this shit. So, unum sanctum. From the latest revision of the text. By the way, this thing, this papal bull, was written on the back of human child skin. Because these scumbags are human sacrificing filth. And that's what these bulls, these ancient papal bulls, were written on. Human child skin. We are compelled, our faith urging us to believe and hold, and we do firmly believe and simply confess that there is only one holy, Catholic, and apostolic church, outside of which there is neither salvation nor remission of sins. That's just, right off the bat, just, yeah. Anyway, I'm just going to skip down to the bottom because I don't want to read this filth. Okay. This we consider false and heretical. This is an aspect. Okay, at least I'll read this then. A spiritual man judges all things, but he himself is judged by no one. This authority, moreover, even though it is given to man and exercised through man, is not human, but rather divine. Being given by divine lips to Peter, and founded on a rock for him and his successors, through Christ himself, him who has confessed the Lord himself, saying to Peter, whatever thou shalt bind, etc., will go forever. Resist the power thus ordained by God. Resist the ordain of God. Thus he makes him believe, like the managing, whatever that is, that there are two beginnings. Right? Two sides of which they'll control. It's a double-headed eagle. Get the point. This we consider false and heretical, since the testimony of Moses, not in the beginnings, but in the beginning, he created the heavens and the earth. Indeed, we declare, announce, and define that it is altogether necessary to salvation for every human creature to be the subject of the Roman pontiff. That is what these fools have been standing on since they created it. A Luciferian spell placed on the back of human child skin, which just decrees that every human creature be subject to the Roman pontiff. As I said, Rome should be destroyed. For no other reason other than this, as far as I'm concerned. But now you see the evil, the true evil that you're actually up against. And why you need to destroy it. And why the founding fathers said, Roman civil law is foreign to us, and get out of here, right? Again, over here. So, that's ecclesiastical scumbag for you, and the history of where that came from. And let me go back to the outline real quick, see how far. I think there's a few other things we got to cover up with the outline. So inferior courts get appealed to appeal and appellate Supreme Courts. We said before, and I showed you why, that a court of record does not get appealed to anything, with the exception of that it could be, unless it's a writ of error that could go directly to a Supreme Court, but only as from an aspect of common law. So you wouldn't be jumping from common law to equity, you'd be jumping from common law to common law, but the Supreme Court justices are supposed to be, they're supposed to know what they're supposed to be doing, meaning as far as the common law side of it. Courts not of record, all crimes are commercial under Roman civil law. There's a CFR for it that I can't remember what it was, so my apologies. There's some CFR that says that all crimes are commercial, but you guys can look it up. District courts get appealed to appellate courts get appealed to Supreme Courts. Supreme Court of a state is original jurisdiction, or is appellate or original jurisdiction. The original jurisdiction aspect of Supreme Courts are for extraordinary common law writs. Makes sense. Quo warranto, habeas corpus, mandamus, writ of right, such and so forth. Equity courts, as we said, are all manners of trust. District courts and Supreme Courts also can deal with equity, basically, and that's where you get the difference between the district courts and the county courts in most states, are where you have the difference between your superior courts of record, county courts, and your district courts, which would be inferior courts. Chancellor, we already talked about that. That's equity, hold the king's conscience, so on and so forth. Maritime Admiralty, which would be, obviously over here, but these deal with maritime admiralty issues, merchant dealings, law of the sea, like I said, prize, so we covered that. Courts martial, that's just for if you're in the military, that's it. That's the only time you ever have to worry about that. And then in the American courts, as I said, there's two different, which I didn't have the separation in here, but there's two different types of courts. You have national United States courts. As to subject matter, it extends to all cases at law and equity arising under the Constitution, laws and treaties of the United States, and to all cases of maritime and admiralty jurisdiction. A case is said to arise under the laws of the United States when the action is brought directly to enforce or protect a duty or right created by that law, or the defendant's defense rests upon a national law, or, again, some aspect of the federal Constitution. So you could drag a state agent, actor, into federal court to say, hey, he exceeded his jurisdiction because I have a Second Amendment right to bear arms, right? Whatever. Or freedom of speech. I mean, we're seeing a lot of First Amendment cases right now. But that's more against corporations. But either way, you get the point. Okay, so then Section 10 here. How to shut down each jurisdiction of law in the proper way verbally in court. This is something I'll cover a lot more in the April classes, but something I just wanted to give a little notice to here. So in common law, you're saying if you know you're in common law jurisdiction, which you're not, but if you knock out all the rest of the jurisdictions, guess what? Common law is the default. So you'd eventually get down to say, where's the damaged party, Your Honor? Oh, the state of Colorado? Oh, please then have the state of Colorado take the stand. Can't do it. Well, okay, then equity. Where's the contract, Your Honor? Or if you're talking to a cop, I have no contracts with the corporate state. What do you want? Maritime Admiralty. I'm the owner of this vessel in question. Who brings claim under what contract? Meaning the body, like your body, is the vessel. So I'm the owner of the vessel in question because it'll have an all capital letters name, which is basically the estate. But so the body is part of the res of the estate. So it's not just your body. That's of the basis of a maritime admiralty contract. It's the totality of the estate. Oh, and one more thing about the word estate, which I don't think I said today. The substantive definition of the word estate means everything that a man or woman owns at law. That is your estate. So your children are part of your estate. Your house is part of your estate. Your land is part of your estate. Your body is part of your estate. Your substantive rights, meaning the right to travel down the road, is part of your estate. The right to life, liberty, and the pursuit of happiness is part of your estate. The Constitution for the United States of America is part of your estate. Because you are, what? A member of the posterity. So, that's that. We'll get into this ad nauseum in April, as far as what to do in courts, right? I just want to say to you guys some various different other places to find more about the law history. And of course, you guys can always go to all of the Vocational Science of Freedom different platforms. We got Library TV and Odyssey and UGEtube, which is one out of Utah, which is a nice backup. Because honestly, anybody else that posts anything on YouTube or that uses YouTube will probably get knocked off of that platform in the next year, if not 2 years. So I'm just taking precautions prior to it. And then the Avalon Project. The Avalon Project is a really great resource to see the history of law, and it's very extensive. In fact, when I first found the Avalon Project, it had maybe, 20 documents on it or something. Now it's got hundreds of documents on it, but it's all being run by one kind of recluse sort of fella who's a very deep researcher. The Vocational Science of Freedom Free Law Library, which anybody who's on the server can have access to, which is in the Law Libraries section under Reference, which is right here. And there's other great law libraries in here as well. Sovereign Education Defense Ministry. This is the archive.org page, which has every single one of these guys' documents on it. Now, note here about the Sovereign Education Defense Ministry. These guys are unbelievable in their research as far as their detail is concerned, but they do not focus very well on solutions, which is what I focus primarily on, and then give as much information as needed so that people can get to the solutions. These guys are almost like the opposite, but the information that they have as far as references and what everything is it's insane. I mean, there's 237 books in this archive.org list for the Sovereign Education Defense Ministry, and a vast majority of the books that these guys have put together, they're over 1,000 pages. So anyway, take that for what it is. You can get, and I did for about a year or two, get lost down the rabbit hole of these guys because I kept looking for solutions, and there was no solution. It was just information after information after information. So it's good information, but pay attention to the fact that there's a reason why you're here. Okay, it's to get solutions. There's the Online Library of Liberty. This one's great. This is all about the foundational documents of American jurisprudence and English as well. This is interesting. Google Scholar, you can look up thousands of cases by just clicking on Scholar Google, and you can look up cases of information that a lot of it was really hard to find a lot of this, or a lot of it was being sucked up and you had to pay for it through various different other services. But now Scholar.Google is basically putting it all up for free. So that's a tremendous resource. And then, of course, there's our Vocational Science of Freedom library, which I add to from time to time. Now, it's not going to have the totality of everything that's in if you buy my entire hard drive. This private VSOF law library is a law library. So, and then 1215.org, obviously, go check that out. Have fun with that. Listen to all of Bill Thornton's lectures as much as you can. And USA versus US. This is also a very, very interesting website that shows the totality of the difference between, and a side-by-side comparison of the difference between what the original de jure republic is and what the corporate fiction is, and when it came into existence and how it was established and how these things got switched back and forth. And it goes on for, as you can see, quite a bit. Like, I've been following this website for quite a while. This website's been up for, I think, at least 20, I think maybe 20 years. I say at least, I know it's been up for at least 15. So, but they keep adding things to it as far as the differences and of a good side-by-side. This is one of the best, it's probably one of the best sites you could ever give a sheep, someone who has absolutely no idea about any of this, just send them this site and just tell them, yeah, find anything that's wrong with this. Like, prove anything on this site wrong. And they won't be able to. But the fun thing is that they'll get lost in so much of this that they'll eventually just come back to be like, okay, what do I do? Right? And here again, legal tender, lawful money, legal tender. Who set it up? Edward Mandell House, right? So again, this gives some of his background of who he was. So Edward and his father had friends in the Ku Klux Klan. The Klan dispensed vigilante justice after the Civil War, blah, blah, blah. So this gives his history. But here we go. Here's the quote that I go over in this lecture in the Vocational Science of Freedom Odyssey page about the total explanation of what this quote, I break this entire quote down literally word by word and explain to you everything of what it is and why it happened and what we're dealing with, which is the aspect of law, Merton, everything that I talked about today. And so that's today's class. And then, like I said, in April, we'll go through the inferior courts, that you do complaints, the injunctions and equity motions and so on and so forth of court process to the inferior courts, and then the court process of superior courts. So the huge difference between this and this. If you get stuck over here, what do you have to do to make sure you get over here? And when you get over here, what do you make sure you have to do to make sure that these guys stay underneath, your boot, basically. So, and I think I covered everything in the links here. Like I said, the foundational documents are here. If you want to read the Carfamaro Cartarum, that's great. The Code of Hammurabi, this is also very interesting because you get an aspect of from 1780 BC, how man was first ruling people by code. And once you realize that this is how far this fight goes back, you can take solace in the fact that, obviously, you're not alone, and that the vast majority of the population of this entire planet, meaning all the way back to here, has been ruled by slavery and code. And that it's about time that we say enough of it. So, does anybody have any questions as far as today is concerned? And you guys can feel free to unmute yourself and go ahead and just ask the question directly so you don't have to type it out. Nobody's got any questions? Well, if you guys come up with anything or have any questions later, you always know that you can direct message me here on the server, and you can feel free to do so. So with that, I thank you, all of you, very much for your support and for coming to class. And I hope that I've done what I can as a good teacher and taught everybody as best as I can what has confused me for a long time and how to get out of it. Hopefully these will be the only 3 classes that anyone will ever need as far as a introduction into how to fix everything that we need to fix. And then they can, we can get going on grand juries and all the other fun stuff. So yeah. So thank you everybody again for your support, and thank you for showing up, and have a wonderful evening. And I'll talk to all you guys on Saturday and Sunday.